Members, Captain Gift Ndamwe. I'm here together with my two colleagues, Anthony F. for the defense, Major Simon, second Captain Daniel Kabombo, second Lieutenant Kampama Albert, and second Lieutenant.
Have you had understood the charge against you?
As you may be aware, the court has not been sitting from 31st of January 2025 when the Supreme Court gave its decision, and we respected the decision of the court, and we had to go to undertake all the other legal processes to make sure that we complied with the decision of the court and the guidance that was given therein. Parliament went through the process of making a new Amendment Act, which was finalized, and our priority now is to consider all the cases that may have been committed between then and now, so that if they cannot be handled by disciplinary action, they are for court, then courts are now open. Last week we had one in a week induction course for all the military judicial officers, for all the units and divisions, plus this general court martial. It ended on Monday. So that's why we have come to start our first session today, and we are going to be handling all those cases which were committed within that time when the court was not in operation. We were banned. There were several issues arising from the decision of the Supreme Court. One was the constitution of that court at the time. People who were on the court, my role, I was there as a judge advocate of the court, but my role was advisory. And the Chief Justice then Emeritus, His Lordship Owinudolo, gave guidance in his read judgment that under exceptional circumstances, civilians may be tried in a military court. And any civilian being charged here, we must cross-check and be sure that he falls within the exceptional circumstances under the law which has been passed by Parliament. So it's not that they are here either by floating the law, but whoever comes here will be in compliance with the law as it has been amended.
What do you mean if you say exceptional?
Ordinarily, civilians, not every civilian will be tried in a military court. But for example, if a civilian commits an offense with a soldier, then that is an exceptional circumstances. He can be charged before a military court.
In the people, among the people you charged today.
And when you are charged is another. So even if you committed the offense in 2023, you have never been arrested, and you are arrested today, you cannot raise it as a defense that you cannot be charged before this court, because as you can see, the charge sheet is reading case number 1 of 2026, and that person has not been charged before this court. Can say is that this is a reconstituted general court martial manned by lawyers who are professional in the field of law. As you saw, 2 of my colleagues are lawyers. I am a lawyer. We all underwent interviews with the Judicial Service Commission. Chairpersons of the panels, each is qualified to be a High Court judge. And we met those requirements. The other two lawyers may not have those qualifications, but they are also on panels. A High Court judge sits as one person, but with the same qualification like I have. So when you have three lawyers trying one case, I'm very sure that you should expect much more than even you can expect outside in the civilian courts.
When you are starting the session, still it is in line with that. You say that some panels will not be presiding, then over will not be presiding in those panels. Could you throw more light on that?
I don't know whether I put it clearly. Under this law, the UPDF Amendment Act, me as the head of the General Court Martial, my panel handles appeals strictly. Appeals are handled by my panel. Then any other cases also like the ones I have handled today, my panel can handle them, but also the other panels can handle both capital and non-capital offenses. But I don't need to be here. As long as it is a panel of three, chairperson, where I have two panels of the same experience, them will be chairing that panel and it will sit as a court martial. Meaning that another court martial can go even and sit in Moroto, or it can go to Guru. If we have capital offenses in Guru or Moroto, we don't need to bring those suspects. Say they must come, be in Ruzira, be in Makinde, and it will expedite the whole case disposal. Because if an offense is committed, for example, in Moroto, witnesses are in Moroto, in Guru they are there, maybe Mountain Division in Fort Potro. So if a court will go, the way you have been seeing the Court of Appeal goes and on session, maybe 1 week, 2 weeks, it handles cases arising from there. So it is also cost effective. Dispensation of justice is much faster. Instead of saying you will be calling a witness, maybe reaching here, it will be a problem. But once you go on the ground, the jurisdiction where an offense was committed, of course, it's not a field court. It's a court seated in a courtroom, but I believe evidence can easily be collected if it is there. Witnesses will come. Instead of saying you have to bring them from Muchisolo to here, that's why some of the delays in cases disposal.
The court that the accused was willing to plead guilty. For that matter, we sent someone to prepare the three facts with the guidance. We seek a standover for a very short time. We may all stay in court as she comes.
What I say will be clear.
My Lord, we sent someone to prepare and print out the three facts, and they are almost ready.
So what I say?
And so my prayer is that you be pleased to grant us a standover, because she's within the premises.
How much time will you work?
My Lord, 5 minutes.
Defense forces in the General Court Martial ordered at Makinde. Criminal case number UPDF for the DCF stroke 004 for 2026. Dated 12 February 2026. Charge sheet. Uganda versus RA 285615. Private Kauka Bernard, a mere adult of sound mind, aged 27 years, a militant of regular forces of Uganda Defense Forces attached to School of Defense Intelligence and Security. As a rifleman, a person subject to military law is hereby charged with statement of offense, absent without official leave, contrary to section 146, subsection 1 and 2b of the UPDF Act. Caption 30. Particulars of offense, Private Kauka Bernard, who is authority left School of Defense Intelligence and Security, but he did not return to the said unit upon the expiration of the period for which his leave was authorized. Have you heard and understood the time? We needed first to finish the issue of interpretation and the interpreters here.
Yes, sir.
If they are there, the one who Yeah, we need the interpreters to take it off. And after that, we'll go to the issue of double representation.
Yes, sir.
Honorable Chair, his name is Muhumuza, M-U-H-U-M-U-Z-A. Is I-V-Y. Honorable Chair.
Let us forget the couple of regulations and get the interpreters. Then you can study.